Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 7th of January 2025, the Clerk of Court in Ada County in the Idaho versus Koberger case released onto the public docket an order sealing defendants' replies to the state's objections to the motion for a Franks hearing and to motions to suppress IGG evidence. This order states the court having before it the stipulated motion to file defendants' replies to the state's objections to Franks and IGG under seal. So I want to just stop right here and point out that this is not Judge Hippler himself deciding these matters need to be filed under seal. It's not the defense's idea that it needs to be filed under seal, nor is it the state's idea and request that these replies be filed under seal. What the court's saying here is that there was a stipulated motion to file the defendant's replies, plural, 2 replies, to the state's objections to the Franks and IGG under seal. So the parties together went to the court and asked that these replies be filed under seal. And you can see the original stipulation. There's a notation to it on the court docket, and we covered this in a prior episode of the Indie Zone. But in any event, let's go back. The court having before it the stipulated motion to file defendants' replies, plural, meaning 2, to the state's number 1 objection to the Franks, and this is a hearing, that's what Mr. Koberger wants, and number 2, to the IGG, which is the subject of a current motion to suppress under seal. The order goes on. The court finds that good cause appears to grant this relief, to file these 2 replies under seal. So the court, having said that the 2 parties have come together, filed the stipulation, asking for these replies to be filed under seal, and good cause appearing for them to be filed under seal. The court now, therefore, it is hereby ordered that the defendant's reply to the state's objection to the defendant's amended Franks memorandum. This is a memorandum that was submitted asking for a Franks hearing. And 2, their reply to the state's objection to the defendant's motion to suppress and memorandum in support regarding genetic information. That's the IGG motion to suppress. Shall be filed under seal, and the court gives the legal authority authorizing this to be kept off the public record. ICAR 32. So ordered, signed by Stephen J. Hippler, District Judge, 6th of January, 2025. So in summary here, there are a number of motions to suppress that are currently scheduled for oral argument per Judge Hippler's October 9th, 2024 pretrial and trial order to occur on January 23rd, and if necessary per that order, it's going to go into the 24th. This motion to suppress the IGG evidence is one of several. Secondly, there is a Franks motion that Mr. Koberger filed. It's an amended motion back on November 22nd. State objected to it. Now comes the reply to the state's objection. All of it is under seal, so we don't know which warrant or warrants Mr. Koberger is seeking to strike. That is what a Franks motion does. Court has to make a ruling now. Will Mr. Koberger be granted this hearing on his Franks motion? That is the ruling that's pending. The pleadings are now closed. We had a motion, a response, and a reply. They're all in now. So all that remains is the court order whether Mr. Koberger met his, again, very high burden of proof. As we have covered in prior episodes of the Indie Zone on this topic, on how difficult it is to get a Franks hearing and why they're so rarely granted. But we will wait and see how Judge Hippler rules. For now, thank you for joining us here today.